record. Hi, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court competition. Today, we are arguing the case of Torres versus Madrid. I am joined by my dear colleagues, Jen Dybel and Chris Riano, who will be judging this competition today. We have two teams. For the petitioners, we have Elena Rembert and Melanie Rojas. Thank you so much for joining us. And for the respondent team, we have Kelly Kim. The petitioners will have 10 minutes. Response will have 15 minutes. And petitioners 5 minutes rebuttal. Counsel for petitioners, you can begin whenever you are ready.
May it please start. Good afternoon, Your Honors. My name is Elena Rembert.
And my name is Melanie Rojas, and we are here on behalf of our client, Roxanne Torres. Your Honor, would you like a brief statement of the facts?
Please.
On July 15, respondents went to an apartment complex in Albuquerque in order to arrest a woman who was not our client. At the complex, respondents saw our client, Roxanne Torres, standing near her car. Ms. Torres had been using meth. Respondents approached Ms. Torres, so she got in her car and started the engine. Ms. Torres did not realize that respondents were police officers and instead thought she was being carjacked. She got in the car and put the car into drive. Respondents drew their guns, and when Ms. Torres stepped on the gas, they fired their guns at the car. Ms. Torres was hit twice, but she continued to drive. She then stole another car and drove to a hospital in Grants, New Mexico. She was then airlifted to a hospital in Albuquerque and was finally arrested at the hospital on July 16, 2014.
In 2016, Ms. Torres sued respondents for violating her Fourth Amendment rights. She argued that they used excessive force to seize her. The district court held that the officers had not seized Torres at the time of her shooting, and without a seizure, there could not be a Fourth Amendment violation. In 2019, the U.S. Court of Appeals for the 10th Circuit affirmed the district court's decision.
The Magna Carta states, "No free man shall be seized, nor will we proceed with force against him or send others to do so." In this case,
let me before we get to Magna Carta, which I always love talking about, maybe I can ask you a question. We're talking here about the meaning of this phrase seizure. What is, I think, the most important historical source you have in your argument? Which historical source do you think supports your definition of seizure the most?
We would say that the most important one that supports our definition of seizure would be, we would say historically would be the Magna Carta because of the timeline and how it lays out, how it's used frequently, how it was used in the Constitution, the wording, and then, yeah.
Are there any court cases you think that help your case?
Yes.
Common law court cases?
Yes, Your Honor. We have California v. Hodari.
But before we get to the 20th century, cases maybe from England, from maybe the 1800s or 1700s that might support your case. No? Okay. All right. You can proceed with your argument.
Okay. The Magna Carta states that no free man shall be seized, nor will we proceed with force against him or send others to do so. In this case, the court is asked to decide whether an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment, or must physical force be successful in detaining a suspect to constitute a seizure.
Counsel,
Yes,
can you help me bridge the gap just a little bit better than you have? And I think that your brief does a great job at this, but I want to learn a little bit more. Can you help bridge the gap between where we're talking about Magna Carta, you're talking about in your brief, the ratification conventions? Can you bring me to how that translates to the Fourth Amendment and how that translates to the facts in this case?
The Magna Carta was written in Latin and translated to English. The direct translation of mitere used in the Magna Carta, it meant put upon. In English synonym would be to admit, meaning to issue formally with authority. Impetu, also used in the Magna Carta, is a Latin word for force. English synonyms are an attack, a charge, and an assault. emit and force have similar meanings. So based on this, we know that the wording in the Magna Carta was meant for something or someone to put or send something onto another person with authoritative purposes.
And you feel that we can translate that forward in this Fourth Amendment context to the facts that you have here that you recited so well previously?
Yes, Your Honor.
And can you just explain that a little bit more for me?
So the Massachusetts Declaration of Rights, which was enacted in 1780 as part of the state constitution, referred to the seizure of a person as an arrest. And so this court has already held that a common law arrest falls within the meaning of the word seizure in the Fourth Amendment because it recognized that the Fourth Amendment protects people against unreasonable searches and seizures in agreement with the common law meaning of those words. Okay, and so we said that yes, an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment. As I stated before, an arrest has been characterized in California v. Hodari as the quintessential seizure of the person and under our Fourth Amendment jurisprudence. So under common law, an arrest can be made in two ways: by a show of authority that causes the person to submit, or by applying physical force with the intent to restrain. An arrest was successful.
If I could interrupt for a minute. So in this case, we all agree that the police shot at the plaintiff, but she was able to then get up and then drive for 75 minutes or 75 miles. Is it the case that her liberty was deprived? I mean, not everyone can be shot and keep going, but she got shot and she kept going. Was her liberty still restrained?
Her personal security was intruded, and it's the fact that she drove away is not what matters for it to be considered a seizure. When the bullet struck her body, that was physical force with the intent to restrain her, and that's enough to make it a seizure.
Well, let me ask you a question then. What about if the police officer, instead of shooting her, tapped her on the shoulder and said, "Excuse me, can you please come here?" Just, tap, tap, tap. Would that be a seizure?
So quoting Terry v. Ohio, it said, "It can be agreed that using a buccal swab on the inner tissues of a person's cheek in order to obtain DNA samples is a search. So virtually any intrusion into the human body will work as an invasion of cherished personal security that is subject to constitutional scrutiny."
Any touching in your mind is a search, is a seizure, I'm sorry.
Enough touching that the officer feels that it would stop the person from moving. It would restrain the person's movement.
Well, okay, so what happens if, a police officer bumps his shoulder by accident into a defendant, or to a suspect? He inadvertently bumps his shoulder. Is that a seizure?
Not if you didn't have the intent to restrain him, no.
Okay. All right, you can proceed.
Respondents argue that an attempted seizure does not fall within the Fourth Amendment, meaning that when an officer applies physical force with the intent to restrain an individual's freedom of movement, but is not successful, then it is not a Fourth Amendment seizure. The common law states that an arrest is successfully made when the officer applies physical force with the intent to restrain, regardless if the arrestee was able to get away. Here it was clearly that the officer did use physical force with the intent to restrain her when the bullet struck into her body. We are not trying to establish that whenever an officer strikes a suspect that there is a Fourth Amendment violation. First of all, that would go against the common law rule that states that an officer must use physical force with the intent to restrain in order to constitute a seizure. Secondly, even though there has been a seizure, that does not mean that the seizure was unreasonable. The Fourth Amendment does not prohibit all seizures, but rather unreasonable seizures. Additionally, that just because an arrest is a seizure, that does not mean that all seizures are arrests.
So let me ask you a question. How would your rule affect policing? Wouldn't this make it harder for police to perhaps apprehend a fleeing suspect if they're always worried about liability and damage suits?
Can you restate your question? Sorry, it cut out.
Wouldn't your preferred rule make it a lot harder for police to do their job because they'd always be worried getting sued for damages?
Well, if the court adopts the respondent's definition of the word seizure, then police officers will not be held accountable for their actions, meaning that police officers would be able to get away with striking a suspect, and there would be no consequences for them as long as that suspect is not under their control.
All right, you have about 20 seconds left. You want to wrap up, Counselor?
Yes, so our client was clearly seized by respondents when the bullets entered her body, and a seizure is made when an officer uses physical force with intent to restrain the individual, regardless if they were successful. In light of the foregoing arguments, we ask this honorable court to reinstate the case and send it back to the district court.
Okay, thank you so much. Right on time. Okay, counsel for the respondent, you can begin, and petitions, you can turn off your cameras.
I think you need to allow me to.
Oh, I'm sorry. Yeah, no, you supposed. Okay, gotcha. How about now? You good?
Yeah, I got it.
I'm sorry about that, Kelly. You can begin whenever you're ready, ma'am.
Mr. Chief Justice, may it please the court. In the Supreme Court case Torres versus Madrid, the question presented today is asking whether an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment, or must physical force be successful in detaining a suspect to constitute a seizure? Officer Madrid and Williamson were planning to arrest Kenyatta Jackson, in which they had an arrest warrant for. On July 15, 2014, the officers went to the apartment complex in which Kenyatta Jackson lived. Jackson's door was open and a woman was seen near her apartment complex. Due to the suspicious behavior regarding Jackson's apartment, the officers decided to approach the woman, which is now identified as Torres, because she could have been Jackson herself, or she could have had information regarding Jackson. Torres got into her car when the officers were approaching her. However, Torres was under the use of the drug methamphetamine and claimed that she was not aware that the officers were officers. She thought that they were carjackers trying to break into her car and attack her. Firstly, the use of drugs could have affected the way Torres perceived the officers. She did say that she was tripping out, and this explains why Torres could have thought of them as carjackers, when the officers were simply approaching her and giving her orders. Evidently, assuming that the officers were in their standard uniforms and had a standard police vehicle, any reasonable person would be able to identify Officer Madrid and Williamson as officers. Not only can the use of the drug methamphetamine be charged as a felony, as in the state of New Mexico, but if she claimed that she was tripping out, it is simply further evidence that she was not in the right state of mind and was not able to leave and was not able to have her best sense of judgment. However, if we look at this in the perspective of Officer Madrid and Williamson, it was not known that the petitioner was under the influence of drugs. And they did not know that they were unaware that they were officers. Reasonably, the officers.
Can I ask a question if I can interrupt? Do people who are on drugs lose their Fourth Amendment rights? Do they, I understand drugs are illegal and tripping is not a good way. It's not a good judgment. Don't do drugs, like Nancy said, right? Are people on drugs? Do they lose their Fourth Amendment rights?
No, they do not. They do not lose their Fourth Amendment rights. However, the officers initially assumed and reasonably assumed that she was not under the influence of drugs, and any normal person would, when officers give them orders, they would obey obediently to avoid any assumptions that an officer can make.
All right, so let's just put ourselves in this position, right? They fired their gun at Ms. Torres. They fired the gun at the plaintiff, right? They shot her. A bullet struck her. How is that not a seizure? Isn't this a really easy case? They shot her. The bullet hit them. I mean, if I were to shoot my good friend Chris over here, he'd say, "You seized me," right? I would never shoot him, right, Kelly? So how is this not a seizure?
So this is not a seizure because, when Torres was shot, apparently she was unaware that she had been shot and continued to drive, leaving the premises of the officers. The Fourth Amendment states that it protects citizens from unreasonable search and seizure. The government may not conduct any searches without a warrant, and such warrants must be issued by a judge and based on probable cause. Additionally, within the meaning of the Fourth Amendment's definition of a seizure indicates that a suspect detained by authorities is unable to leave by their own free will and also cannot ignore an officer's request.
Let me ask you a question, right? Let's, I take it that the police in this case was very strong, right? Most people, when they get shot, they stay down, but she was Superwoman, right? And she kept going. Is that the rule that if a person's weak and they fall down from a bullet, they're seized, but if they're strong and they keep going, they're not seized? Is that the rule that you want us to adopt?
When Petitioner Torres was shot, she did not show any sign of restriction or physical restraint. And the correct definition of a seizure under the Fourth Amendment, which is also proved by previous cases, shows that states that the petitioner, the suspect should be detained by authorities and not be able to leave by their own free will and not ignore the officer's request. However, Torres was able to leave the premises, drive 75 miles out of the vicinity of the apartment complex in which the officers were, and she was able to steal another car and drive to another hospital in Albuquerque in which she was treated in.
Well, what are some of those cases, Counselor, you mentioned?
Sorry, can you repeat that?
You mentioned cases. Can you maybe tell us what some of these cases are?
Yeah, so in previous cases, similar situations are present, such as Broward versus County of Inyo. Broward had stolen a car and he was driving over the speed limit. The police were trying to detain him, but a police roadblock was set in place to try to prevent him from escaping. The roadblock was hidden on a curve and hidden by lights of an 18-wheel tractor trailer. And although Broward was able to be stopped in this roadblock, the actions of the officers was not constituted to be a seizure because Broward's actions were beyond the control of the police. The police did not have authority over Broward as he was already fully capable to operate his vehicle, and he ignored the officer's request and left by his free will, which defies the correct definition of a seizure.
Okay. If any other colleagues have questions, you're welcome to jump in.
I'm actually looking at your brief, Counselor, and I like some of the arguments that you've been putting forward, but I'm curious to kind of continue to explore what we were just talking about, because I want to understand better in the Fourth Amendment context, but even outside of the Fourth Amendment context, how being shot in a warrantless, I guess, essentially hot pursuit-esque moment is not a seizure. It's not, regardless of the fact that, as Justice Blackmun mentioned, she was able to be Superwoman and drive away. And how is that not the very definition of state action, right? Police officers and state action seizing without a warrant, regardless of what we can talk about under the Fourth Amendment. And how is that not something that we should be considering when we're thinking about the rules that come from the facts of this case?
When we look at previous cases, as I said, Broward versus County of Inyo, the court has confirmed and concluded that Broward's actions when driving the vehicle was beyond the authority of the police, and that the officer's actions would not be constituted as a seizure. And we would look at these previously ruled cases and apply the same conclusions upon this case, which would imply that the actions of Officer Madrid and Williamson would not be considered a seizure.
Let me give you a hypothetical if I can, Counselor. Let's say, right, in your case, the police shot at the plaintiff, right? I got that. Let's say they tried a different tactic, right? Let's say that she was driving on the highway at 75 miles an hour. And the police called ahead to their friends who put a roadblock in the middle of the highway about a mile ahead of her. They put the roadblock up and they put it up there at night, and she wasn't able to see it. She couldn't swerve out of the way, and she slammed into this roadblock and broke her arm and paralyzed her arm. Now, the police didn't touch her. They just put the roadblock up. She had, it's like, she just drove into the roadblock. Would that be a seizure?
No, that would not be a seizure because a similar situation did happen in Broward. It was a roadblock, but Broward did have his own will. He was able to make his own decisions, and that was out of the authority of the police, in which that was what led the police to make the roadblock.
I'm saying she's going 75 miles an hour down the highway. She can't swerve. It's dark. She can't see it. She has no choice but to slam into the roadblock. Is that you still think it's not a seizure?
No, because they're still beyond the control of the officers in a vehicle. They're beyond the authority of the officers in that moment.
Well, let me ask the question they gave to your friend on the other side. If an officer taps a person on her shoulder and says, "Excuse me, ma'am, can you please come talk to me for a minute?" Is that a seizure?
I believe that is not a seizure because they are not harming them in any physical way. They're simply asking maybe something regarding information that they need from a suspect, etc.
So then what does it take to actually seize a person in your mind? What would actually be a seizure?
So to seize a person, they need physical force that is successful to detain a suspect.
So
They need
successful. So that is that your key determinant? It's got to be successful. They have to actually succeed.
Yes.
All right. So I mean, what happens? Like, the police are trying to bring down, like Arnold Schwarzenegger. It's like a really strong guy, right? And they're beating him, and they're grabbing him, and they're hitting with their nightstick. And Arnold's like, "Yeah, right," and he just pushes him away and runs away. Is that excessive force beating and slapping not a seizure because it wasn't successful?
So that would not. Well, if the person that was getting attacked did get away,
Yeah.
although they were physically harmed, it would still not be considered a seizure because he was able to get away at the end.
Wow. So really your rule depends on how strong the person is, right? If the person's really strong and mighty, it's not a seizure. But if we're like little meek and weak like me, right? I go down to first blow, there would be a seizure. Is that the rule?
Well, if the person that's getting attacked or the person that's getting physical force upon, if they aren't physically restrained, it is not a seizure because, well, that is just the basis definition of a seizure. That was previously ruled in previous cases.
Let me ask this, counselor, even if it has been previously ruled in previous cases, and I'm not necessarily disagreeing with you, does that necessarily mean that we should find the same way here, given this fact pattern?
Well, it would be assumed that we would go by those previously ruled cases. It wouldn't make sense if similar situations were present and if the actions of the officers were also similar. We would also go by the same conclusions that were formed on the cases that were confirmed and concluded.
Absolutely. And I think that that's a wonderful way that you just argued that. And I want to push it just a little bit further and say that as much as we can take from prior cases, I'm not aware of a case where we have a situation where officers are going after with a warrant one individual, they come upon another individual, they shoot that individual, and then that individual is able to drive away, and then there's a Fourth Amendment question. So as much as I think our decision is informed by that, and I completely agree, this is obviously a unique fact pattern. So I just want to get your thoughts on that, since we obviously will have to make a determination based on the unique fact pattern that's in front of us.
Oh, so you're asking if this should change, if this,
Mhm.
Okay. So I believe that since the Fourth Amendment states that it protects citizens from unreasonable search and seizure, the officer should, it should only be considered a seizure when the officer is able to detain a suspect, because other than that, the suspect has their own free will and they have their own decisions so they no longer have to be protected in a way. Even though they are physically attacked, they are able to protect themselves out of the Fourth Amendment.
So, Counselor, maybe one more question. Do you think that the Supreme Court decision Hodari D makes us rule for the plaintiffs here? In other words, did Hodari D resolve this case for us? Is there anything left for us to even do here?
No, I think Hodari did conclude the rules and the definition of a seizure that has been that has been demonstrated throughout these other cases as well.
Okay, so the Hodari's holding does not dictate the outcome in this case.
No, I think it further evidence that we should push that Officer Madrid wasn't guilty in this case.
Okay, you have about a minute left, counsel, if you want to wrap up to your conclusion.
So the petitioner may also argue that the bullet wounds with no identifiable exit wounds would extend to constitute a seizure. However, this cannot indicate any restriction or physical restraint by the officers, as she continued to operate the vehicle without hesitation after she was shot. It is urged that the court forms their ruling of the case concerning Torres and Officer Madrid and Williamson on the basis of the definition of a seizure. A seizure under the Fourth Amendment indicates that the person is unable to ignore an officer's request and leave the authority of an officer. So a violation of the Fourth Amendment would only be when the person is detained by the officer. Torres' Fourth Amendment rights were not violated, and she was capable and fully able to operate and leave the officers by the use of her vehicle. Torres was not physically restrained, and therefore physical force must be used and successful in detaining a suspect to constitute a seizure under the Fourth Amendment. And as this did not happen in Torres versus Madrid, this cannot be considered a violation of the Fourth Amendment. Thank you.
Excellent. Thank you so much. I know you're solo. Your partner couldn't make it today, so kudos to you for going solo. That's not easy. 5 minutes, please, for petitioners. If Kelly, just turn your camera off, and if the petitioners turn the cameras back on, we can see everybody. Okay, Counselor, 5 minutes. Begin whenever you're ready.
We'd like to correct something respondent mentioned about Brower. A respondent said that there was not a seizure in this case, but the court held that there was a seizure and that it was illegal.
The concurring argument in Brower states that the majority establishes a test for Fourth Amendment violations based on police intent. In our case, this intent has been proven. It has been made clear that when a suspect is shot and killed, that there is a seizure. A suspect should not have to die to be protected by the Fourth Amendment. Our client was shot with the intent of restraint. Though she did not die, nor was she arrested at the time of the incident, she was seized under the common law definition, which states that an arrest is made by a show of authority that causes a person to submit or by applying physical force with the intent to restrain. If the court decides not to use
let me ask you the same question I asked you again before. Tapping on the shoulder, is that enough for a seizure?
Not unless the police officer had the intent to restrain them or felt that it was enough force to restrain them.
And so how are we supposed to figure out what the intent is of the police officer? I mean, they're always going to say, of course I didn't intend. You ask a cop, like, no, I was just, tap, just tap on the shoulder, right? I get your rule. I know the rule you want us to adopt, but how are we supposed to actually administer that rule to know what an officer's intent is? They're probably going to lie anyway, right? They're going to make something up or at least exaggerate. How do we know what the officer's intent is?
I can't answer how I know what every officer's intent is, but I can say that the police shooting at our client 13 times is very clear that they had the intent to restrain her.
Right. So you don't want to give an answer to the hypothetical. You just want to say, but this case should be easy enough to resolve. Is that where you are?
It's not easy to answer the hypothetical because we don't know what all police officers are going to do.
Okay. All right. You can proceed with the argument, counsel.
If the court decides not to use this definition, the police will not be held accountable when they shoot someone with the intent to restrain them and intrude on their personal security. Thank you.
Okay. Any questions from my colleagues? Mrs. Dybel, anything? No? All right. Well, thank you so much, counsels. All right. If everyone can just come back on camera, please. Kelly, Mr. Steele as well. He might be here. All right. Well, thank you so much, both teams. You did a fantastic job. You have to know the questions we're asking are not easy, and that's why we're asking them. We were trying to throw you off your game at every juncture, and we're trying to get you to commit to something, because once you commit to it, then there's a follow like, well, the answer to this is this. Why isn't it that? Right? And then we can sort of just knock you over. And I think you all held your ground pretty well. I think you did the best you can to answer questions, and I'm very impressed. And I know Mr. Seal's been coaching this for many years, and your students really are impressive. I couldn't have done this in high school. Chris, Jen, I don't know about you guys. I sure as hell couldn't. I couldn't have told you what Magna Carta was when I was 16 years old. I didn't know. But this is really, really impressive, and I want to thank you all for your excellent work. Chris, anything you'd like to add?
Yeah, I just want to jump in. I have to say I was super impressed. I only ask hard questions when I know people can answer them. And so to see 3 young women of color who are all able to answer these questions when I could never have done this in high school is so impressive. I think all 3 of you should give yourselves a round of applause. That was amazing. And I have to say, I have had the opportunity. I'm the president of the nation's Center for Civic Education. So I have had the chance to judge students around the country when it comes to incredible different things. And I'm also on faculty at Columbia. And I have to tell you, I love having the opportunity to spend time with students like the 3 of you, because you clearly have the knowledge. You all were pivoting just like I've pivoted when I've been in front of appellate courts. You all were able to recite and get the information out there when you wanted to. You were able to dodge some of the harder things that we were asking, but still stick to your points. I found it really interesting to think through the idea that a seizure has to be successful in order to be a seizure. I mean, it's not easy to stick with, especially when you have people who are saying, that doesn't make any sense. Do you want to say something else? And you're like, no, I'm good. I appreciate that. That's actually the way you do this often in real life. So I want to say congratulations to all 3 of you. I know, Ms. Kim, I know that you didn't have your partner. That's an extraordinary thing. I have had to jump in and do that myself in appellate arguments at the very last minute. I'm sure that Josh and Jen have as well. That's an incredible skill. But Melanie and Elena, I mean, really, you did a wonderful job. I have to also mention, you can tell that I'm sitting here citing your briefs. I always go back to the briefs because I think that that's such a core piece of what it means to be a lawyer. The briefs look good. The arguments are good. I like Josh is the first person that's going to say, "Ooh, Magna Carta, let's go," because that's what I teach. So I get very excited when we have a chance to see that. All 3 of you are putting in great facts in the briefs and able to argue. So you should be coming out of this feeling very proud of yourselves. I know how much work you've put into this, and no matter what else happens when it comes to next steps, really, I do say this, congratulations, you should be thrilled. It was much better than anything I could have done in high school, and frankly, a lot better than what I see from my students at Columbia.
True. Jen?
Yeah, I'm not usually a person of few words, so I apologize for not jumping in at various times, but my colleagues were asking the questions that I knew needed to be asked, and you were answering them very, very well. So thank you. Your commitment to this and your preparation just really, really, really was clear to, I'm sure, all 3 of us throughout, and as the others have already mentioned. And I'm very, very impressed with your, not only your writing in your briefs, but now today, hearing you speak and present your sides. And I 100% agree. It was very impressive to see you stick with your side of the story and your side of the argument, and be able to say, nope, I'm good. This is what I believe. And this is where I need to be, because especially when you're newer to this, or you're younger in your careers, or our careers, I think it's much easier to think, oh, well, maybe I'm not right. Maybe, or to get thrown off by the questions that you're hearing. And so I was very, very impressed with your ability to stick to your guns and know that this is what you believed, and this is what your side believed anyways. And I'm really proud of you. Just, you guys worked really hard, I know, and you probably put tons and tons of time into it. So thank you for all that you did to prepare for today. And congratulations on a really successful argument, both sides.
Thank you. If I can ask, do any of you plan to consider law school? Maybe thinking about lawyering? Elena, Melanie, Kelly, what are your plans? Yeah, Melanie, yes, lawyer?
Yeah. I want to go to law school.
Oh, that's awesome. Well, Kelly, how about you?
Yeah, I enjoy doing stuff. I'm not like sure what I'm doing, but I really like talking and stuff about like.
All right. Well, I'm a law professor in Houston. So maybe next year, if you're ever in Houston, you're welcome to visit my class, or you can come by on Zoom. Hey, Greg, what do your students do Mondays and Wednesdays from 1:30 till 2:30? Do you have your students then?
Our Wednesdays vary. Wednesday is kind of a flex day. Alternates between A and B days. Monday, what time did you say?
1:30 till 2:30. I'm teaching my First Amendment class. Welcome to watch on Zoom. Welcome to tag along. If you want to maybe just bring over your students.
I have my kids in the morning
All
on
right.
Mondays and Tuesdays and alternate Wednesday, Mondays and Thursdays and alternate Wednesdays. I do have one group of sophomores in the afternoon on every other Wednesday. But I've got these guys in the morning. Now, having said that, we love the opportunity to go and visit, even virtually,
Yeah.
any law school class that might have their open door.
All right. Email me, Greg, after this. I only have a couple classes left. The semester is just about over, but I'd love to have your kids come by. Just sit in on Zoom. They can just watch it. I have First Amendment. The semester's almost up, but they're welcome to come sit down in class.
Let me ask a quick question. Professor Blackman, I certainly know you, and I think I recognize Professor Riano and Ms. Devil, but I don't know that I've ever been introduced or actually know what you guys do. Would you mind filling us in a little bit?
I can go very, very quickly. I am a graduate of Ohio State Law School, and I went right into a career in tax. And so I wasn't necessarily doing this kind of thing, but I'm an Ashbrook Scholar originally. So the Ashbrook Center is very near and dear to my heart. And that's how I learned about this competition, and the opportunity to sit as a judge came to me that way. So I am a tax attorney.
I'm at war with the IRS right now. I may email you.
Not me. I'm sales and use tax. So I even have a very specific niche. That's how.
I've got a capital gains problem I'm working with.
Yeah, ladies, that's how much of a niche you can carve out for yourself in the law. So I specifically work with corporations and in sales and use tax.
And Professor Riano, I gather you were teaching at Columbia.
Yeah, so I have kind of two things. I started my career, I was a partner at a firm doing work for high profile, high net worth individuals before, and I've always been on faculty at Columbia, where I teach constitutional law and government, and kind of the jurisprudential ways in which that's come to fruition. Prior to becoming the president of the Center for Civic Education, I was one of Governor Cuomo's counsels. And before that, I was the head general counsel for the New York State Liquor Authority. So I've been able to kind of do a lot of very interesting different things, always keeping one foot in the academy and one foot in practice.
You don't half old enough to do any of that.
I appreciate that, sir, because I assure you that the day that somebody says the opposite, I will know that I have finally emerged from that point in my career. But it's one of the reasons why I so enjoy this, is because my whole entire career I've spent having a chance to work with both students and practice. And so it's so exciting to see students get to do this, because my practice was appellate work. And I still chair one of the sections of the New York State Bar Association. So, I mean, it's really exciting, because I think one thing that's really great about this is the skills that students now will have, Ms. Kim and Ms. Rembert and Ms. Rojas, lawyer or not, these are skills you will use in your life. Well, having the opportunity to do this is a very powerful skill set to have.
What I tell our kids, we try to compete 4 or 5 times a year if we can, but there is never, ever any competition that has the level of judging that Mr. Blackman brings to this table. And I want to thank you guys.
Thank
Y'all
you.
would make
Thank you.
Such an incredibly valuable experience.
No, and to you, Greg, you fielded some good teams this year, and not all of them advanced. It's getting tougher to advance, and you just have to realize that. Greg's been doing this now for a couple of years, and every year fewer of his teams get forward to the next round. So Elena and Melanie, congratulations. Kelly, I think this is your first year you guys participated, so I hope. I'm from Staten Island, so I know Syosset very well. So more New York teams can play next year.
What year are you, Kelly?
I'm a sophomore right now.
So are Elena and Melanie. We'll see you next year, girl.
Next year. See you
Good
next
job.
year. All right, the three of you have any questions for me or Chris or Jen that you want to ask?
I wanted to ask
Sure, either one, whoever.
I wanted to ask a question to Mr. Rihanna. I think it's so interesting that you're like that you do both, that you teach students and that you you have I wouldn't say like more professional, but like two different ways. And I like that so much because a lot of the time they tell you, oh, you can have one job and you do this and you do it this way. But I like that you have so many different things and they're all in law and they all like go around each other. And that's so cool. And it really interested me.
I'm the first person that will tell students that I don't know how I was able to always manage having lots of different things that I got to do, but I've at least found it to be a really rewarding opportunity because when I want to go and practice, and I did some briefs in front of the Supreme Court this year, I could do it. And when I want to go teach, I get to teach. And when I want to work in the nonprofit sector like I'm doing now, I get to do that. And I think the key that I would say is this, and I'm sure that Jen and Josh would say the same thing. A law degree is a lot more flexible than sometimes it may seem. It's probably one of the most flexible things that you can study because it teaches you how to think and it teaches you how to do things that aren't necessarily even tax law, which is my least favorite thing, and I do not understand it at all. And so I give a lot of credit to anybody who does because I can constitution it all day long. I couldn't write my own taxes. I've never been able to do that. So I'm the first that says, I always encourage my students to follow their passions because I think when you're passionate and you're excited and you find something you really care about, you find ways to make it into a career. So that's kind of what I would say about that.
And Kelly, did you have a
I
question
can't
also?
do my own taxes either.
Kelly, did you have a question also?
Yeah, I just wanted to ask if like you guys have any advice for us.
Sure. Find something legal in your neighborhood. Maybe there's a law firm looking to hire a summer clerk. Maybe there's a judge looking to hire a summer intern. Maybe write to your local member of Congress or your local state rep and see if they're looking for an intern for the summer. Probably won't be paid, but that's okay. You don't always need to get paid right away. But just get yourself in an environment surrounded by lawyers, and you're all smart students. You'll sort of absorb the language. You'll absorb what they're saying. They may give you different ideas. Maybe they'll give you a book to read or maybe an article to read. If you can find a way to even just go to a courthouse, right? I mean, now COVID, it's a little more difficult, but eventually courts will be open and they're open to the public. You don't need an excuse to go and you just walk in and say, I want to sit through a criminal trial, right? Or I want to watch an attorney argue over a probate of a will, right? Or God forbid, a tax case, right? Sorry, Jen. I'm sorry. I don't know tax either. I use TurboTax. But just walk into a courthouse. I think in Texas, at least, the courts are open for business. You can walk in with a mask on. Not sure about New York, but walk in and just watch. And
I would say also, first of all, you're already leaps and bounds ahead of your peers because you have had classes like this and the opportunity to understand how to write a brief and how to prepare an argument. And so use those experiences as you're asking for those opportunities. I mean, definitely play those up because you are unique in that way among your peers. And then also recognize that there are so many different things in the law that you can do. That does not mean that you have to, yes, it's exciting to go and watch a case in the court, but you may never go to court. Like there are so many opportunities within the law that don't have anything to do with actually arguing a case. So just start talking to lawyers or asking questions about what they do and whether they go to court or not. I mean, a very small percentage of people actually are actively participating within a courtroom. So know that there's a lot more out there for you than just that.
Yeah, I just want to echo that. And I'll say, Ms. Kim, to your question, I mean, when I was a sophomore in high school, it's actually the first time I volunteered at a district attorney's office. It ends up being the same district attorney's office that I ended up practicing at because they had known me from when I was an intern. And it was enough to where, as a second-year law student, so my second year in law school, while most of my friends were doing moot court, I was certified to practice. So I was practicing in court as a 2L. And it's because of my sophomore and junior high school internships. So it's never too early, just like Josh mentioned, to start getting involved in the community. And I would say that broadly, because that's really what law is. It's the relationships we have. And that just means being part of your community and finding ways to be involved in your community.
Is there anything else you want to ask us, guys?
One more question. I was just gonna say, what would be the best way to reach out
Sure.
to other?
Yeah, okay. Greg has my email address, but I'll just put it in the chat, and that might just be easier. You guys are welcome to email me, but Greg knows how to find me. And again, seriously, Greg, let's make this happen. I have 3 classes left for the semester, so maybe it's not this week, next week, but then the semester's over. Try and get at least some of your kids into my first medical class, just so they can just sit on Zoom. Don't even have to have their cameras on, just to watch it.
Did
Yeah,
you say that you only got 3 classes left for this
Yeah, I'm
semester?
almost done. Just about done for the semester. Yeah.
Wow, we're extended into June. Are you going to have a summer semester?
No, we're done.
Okay, so I need to get hold of you quick. Okay.
If they're even in class all day right now, or are you like in person in school, or are you, if you're not in person in school and you have more remote schedules, I don't know how strict they are at 1:30 each Monday and Wednesday, for example. Perhaps there's an opportunity that way.
Greg, we can figure this out by email later, okay? I want to make sure we have enough time for the next session coming in about 10 minutes.
We do. We do.
All right, so let's adjourn. I'll stop the recording here. So thank you all so much. This was delightful. We'll be announcing the scores on Monday, so stay tuned. But you all did wonderful. So thank you all so much.
Quick question, Josh. Last year we went from here to another round.
We're gonna figure that. We'll get to that later. We're still figuring the details out.
Gotcha.
Okay, thanks so much. All right, everyone, take care. I'll turn off the recording. If the students